We've got some shocking legal news tonight, no hyperbole. This is the kind of development you almost never see in the federal court system. And if you care about the Second Amendment, you'll want to pay close attention. The United States Court of Appeals for the Fifth Circuit has just withdrawn its prior ruling in the United States versus Peterson case. Not amended, not softened, completely pulled. From a legal standpoint, it's as if the decision was never made. This is huge. Why does this matter? Because back in February, that very court issued one of the most damaging anti-gun decisions we've seen in recent years, ruling that suppressors, those cylindrical muzzle devices that cut down on sound and protect your hearing, were not covered under the Second Amendment. It was a brutal blow to gun owners and anyone familiar with real-world firearms use. But now, that ruling is off the books, gone. And that has major implications. I'm going to walk you through exactly what happened, why it's a game changer, and how this could shift the future of gun rights in the United States, especially if you care about silencers, the National Firearms Act, and whether the judiciary is finally returning to a constitutional originalist view. So stick with me, hit subscribe if you haven't already, and let's break down what could be one of the biggest wins for gun owners this year. Here's the background, real quick. The case United States versus Peterson centers on a man who got charged for having a suppressor that wasn't registered under the National Firearms Act. If you know the NFA, you know it treats suppressors about the same as it does automatic weapons. Full-on regulatory nightmare. You've got to register with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, fork over $200 in tax, and then wait potentially over a year just to legally own a tube that muffles gunshots. But this case wasn't just about red tape, it struck at the very foundation of the Second Amendment. The key question, does the Constitution protect suppressors as arms? In February of 2025, the Fifth Circuit said no. The panel, led by Judge Jennifer Elrod, argued that suppressors don't count as arms because they don't fire bullets, aren't deadly on their own, and are more like add-ons than actual weapons. That was their logic. And let me tell you, that decision hit like a shockwave. Second Amendment attorneys, everyday gun owners, and even some folks in the Department of Justice under the current administration were fired up. Why? Because it flat out ignored the Supreme Court's clear guidance in Bruin, which said that all tools used for armed self-defense fall under Second Amendment protection. And that's not vague, that's in the opinion. Suppressors reduce noise, manage recoil, improve accuracy, and let people defend themselves while protecting their hearing. Saying they're not protected? That wasn't just misguided, it was dangerous. But now, just a few months later, the court has pulled that opinion completely. It no longer exists. That's a major shift, and it could change the whole legal landscape moving forward. The February ruling wasn't just a minor mistake, it was a full-on breakdown in constitutional reasoning. The court claimed suppressors don't meet the definition of arms under the Second Amendment because they don't launch projectiles. But that argument completely contradicts how the Supreme Court has already defined that term. In District of Columbia versus Heller, and again in New York State Rifle and Pistol Association versus Bruin, the High Court made it clear, arms are not limited to muskets and flintlocks. The term includes anything that facilitates the act of self-defense. And that includes modern firearms. That includes accessories like scopes, lights, and yes, suppressors. This isn't even a radical interpretation. It's what the Supreme Court has already laid out. Suppressors do one thing incredibly well: they help preserve your hearing and give you better control over your firearm. A quality suppressor can bring down the report of a gunshot by about 20 to 30 decibels, which is a huge benefit whether you're out at the range or dealing with a real-world defensive scenario. According to a study published back in 2020 by the National Institute for Occupational Safety and Health, just one unprotected shot can cause permanent hearing loss. Suppressors help prevent that, and that alone makes them invaluable. But here's the kicker. The court's previous ruling completely ignored the widespread, lawful use of suppressors in the United States. As of 2024, more than 3 million suppressors are legally registered with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. These aren't obscure, fringe devices. They're used by hunters, competitive shooters, homeowners, and yes, even law enforcement. The United States Marine Corps equips their infantry units with suppressors for both tactical effectiveness and long-term hearing protection. If America's warfighters are using them, why would any court say everyday citizens shouldn't? And the biggest issue? The panel completely failed to apply the historical analysis required by the Bruin ruling. Instead of examining the Second Amendment through the lens of original meaning and historical precedent, they treated suppressors like some kind of modern luxury item, something optional or decorative. That kind of thinking doesn't just miss the point, it threatens the entire structure of constitutional firearm protections. When the decision dropped in February, it sparked outrage across the Second Amendment landscape. Why? Because if suppressors aren't protected, what's next? Bipods? Optics? Lights? The moment you start carving out exceptions, the definition of arms becomes meaningless, and that's exactly what made the withdrawal such a pivotal moment. On June 17, 2025, the Fifth Circuit quietly issued a brief but forceful order. Their previous opinion in United States versus Peterson was officially withdrawn. No footnotes, no clarification, just a one-line statement that reversed course. And to be clear, this doesn't happen all the time. It's rare for a federal appellate court to rescind a published opinion. Usually, a ruling like that sticks unless a higher court reverses it or it's reheard by the full bench. So for the very same three-judge panel to backpedal and reopen the case, that tells you everything you need to know about how flawed the original decision really was. So what turned the tide? One of the biggest drivers behind this reversal was a change in stance from the federal government itself. When the initial ruling came down in February, the Justice Department under the incoming Trump administration filed a brief backing the court's view that suppressors didn't qualify as protected arms. That move blindsided a lot of folks, especially given all the talk about defending Second Amendment rights. But the tide turned quickly. Once John Sauer was confirmed as Solicitor General and Harmeet Dillon stepped in to lead the Civil Rights Division at the Department of Justice, the federal government reversed course. They submitted a new brief making it crystal clear: suppressors are constitutionally protected. They backed up the claim with evidence of lawful use, health and safety benefits, and even referenced their widespread adoption in the military. That policy pivot may have been exactly what the panel needed to save face and reconsider, because at that point, they weren't just ignoring the gun community, they were out of step with federal leadership and constitutional law. So where does that leave us now? We're essentially looking at a reset. The bad opinion is off the record. The case is once again active, and the same judges who misfired the first time now get a second chance to get it right. That doesn't happen often, but when it does, it's proof that the legal system at least sometimes can still course correct when it matters most. The moment that withdrawal order went public, the energy shifted. You could feel it across the entire Second Amendment landscape. From grassroots activists to constitutional lawyers, the reaction was immediate and overwhelmingly positive. Groups like the Firearms Policy Coalition and Gun Owners of America were quick to call it a major victory, not just because the Peterson opinion was vacated, but because this could signal a broader change in the courts. Here's what's really happening. Judges across the country are starting to reevaluate how they approach Second Amendment cases now that Bruin is the law of the land. For years, anti-gun rulings leaned on a so-called interest balancing test. That framework basically said, yes, you've got rights, but if the government has a good reason, they can override them. That's no longer acceptable. The Bruin standard is crystal clear. If the government wants to restrict your right to own or carry an arm, they need to show that the regulation aligns with historical tradition. Full stop. And let's be honest, there's zero historical precedent for banning suppressors. The National Firearms Act didn't even exist until 1934. Before that, suppressors were just another tool. You could buy them at hardware stores, order them through catalogs, or pick one up with your rifle from your local shop. Ads in old outdoor magazines marketed them as helpful gear for target shooters, hunters, or folks living near neighbors. They weren't treated as evil or dangerous, they were just gear. The idea that suppressors should now be seen as outside the scope of constitutional protection is not only ahistorical, it's absurd. The Department of Justice's new stance drives that point home. In their revised brief, the government argued that suppressors serve multiple constitutionally grounded purposes, supporting lawful self-defense, improving firearm control and accuracy, and reducing permanent hearing damage. And they didn't stop there. They cited the United States Marine Corps decision in 2020 to begin issuing suppressors to frontline infantry units. That is not a fringe use. That is top-tier institutional endorsement. More importantly, the Department of Justice recognized that suppressors improve situational awareness, especially in high-stress defensive scenarios. That's not just about comfort. That's about survival. Being able to hear footsteps, voices, or commands while protecting yourself or your family inside your own home is not a luxury, it's a basic necessity. So when you place those facts, historical context, and constitutional principles on one side of the scale, and the now abandoned reasoning from the Fifth Circuit on the other, the comparison isn't even close. The law, the record, and public support are all lining up behind freedom, and that's what makes this moment so important. This wasn't just a win for suppressor owners. This could be the first domino in a larger legal shift. A reversal like this one opens the door for major changes in how courts treat things like magazine capacity limits, pistol brace rules, and semi-automatic rifle bans. Because at the core of this case is one defining question: what counts as an arm under the Second Amendment? If suppressors qualify, and clearly, they should, then all other commonly used firearm accessories and configurations gain legal traction. Take so-called high-capacity magazine bans, for example. States like California and New York continue trying to outlaw standard magazines that hold more than 10 rounds, claiming they aren't essential to self-defense. But under the Bruin framework, that's not the question. The real test is whether the item is in widespread lawful use, and standard magazines are used by millions of responsible Americans every single day. Apply that logic to suppressors, and it becomes clear. If the Fifth Circuit acknowledges them as protected arms, it will become far harder for other courts to justify bans on magazines, braces, or rifles in common civilian use. And that's exactly why anti-gun groups are worried. Because one reversal like this sends a loud message. Courts are no longer giving a pass to unconstitutional firearm restrictions. This shift also places fresh scrutiny on the National Firearms Act itself. For nearly a century, the NFA has existed as though it were legally untouchable, but it was never built on constitutional bedrock. Short-barreled rifles, suppressors, and other items placed under its authority have long been treated as though the Second Amendment didn't apply. That illusion won't last forever. If suppressors are recognized as protected arms, then subjecting them to a $200 tax and a months-long approval process becomes a serious constitutional problem. You cannot place a special tax on a fundamental right. The Supreme Court has said as much in prior decisions like Minneapolis Star versus Minnesota and Harper versus Virginia Board of Elections. Rights aren't subject to a surcharge. Some folks might argue, suppressors are still legal. You just need to go through the process. But that misses the point entirely. When the government imposes a heavy tax, delays lawful use by many months, and threatens criminal charges for non-compliance, that's not regulation, that's suppression, not just of sound but of liberty itself. This is about more than one court case. We are watching the beginning of a legal movement that aims to challenge not just individual rules, but the entire regulatory framework that has grown unchecked around the Second Amendment. That is why this moment matters. That is why we can't just take the win and walk away. This withdrawal was not the conclusion, it was the opening volley in what could become a full-scale legal realignment in favor of the Constitution. And this is where you come in. Because even though this reversal is a big deal, it is only the beginning. The case remains active. The panel will likely draft a new opinion, and it could still escalate to a full en banc hearing in the Fifth Circuit. That ruling would then set precedent for tens of millions of Americans living in Texas, Louisiana, and Mississippi. We cannot afford to sit on the sidelines. If you care about your rights, stay engaged. Read the legal briefs. Track the court filings. And most importantly, support the legal teams doing the real work. Groups like Gun Owners of America, the Second Amendment Foundation, and the Firearms Policy Coalition are on the front lines, pushing these arguments where it counts, in court. Call your representatives. Let them know you support legislation like the SHOOSH Act, which would remove suppressors from the National Firearms Act altogether. That bill has been floating in Congress for years. With the right support, it could finally move forward, but only if we demand it. Enough is enough. It's time to stop treating constitutional rights like permissions that can be taxed, delayed, or denied. What just happened in the Fifth Circuit wasn't a minor correction, it was a turning point. When a federal panel pulls its own ruling, it means they knew they got it wrong. Now, they've been given the rare chance to make it right. This momentum belongs to every American who refuses to compromise on the right to keep and bear arms. But the momentum only lasts if we keep pushing. If you believe suppressors deserve full Second Amendment protection, now is the time to act. Stay vocal, stay vigilant, support the groups in the fight, and let's keep the pressure on. Subscribe for updates, follow the court schedule, and stand shoulder to shoulder with those defending liberty in the courtroom. The other side never stops organizing, and neither should we. We'll see you in the next fight.